The announcement of New South Wales's roadmap to freedom made a clear distinction between vaccinated and unvaccinated Australians. Whilst vaccinations have not been mandated, conditions surrounding freedoms offered to vaccinated persons and not to unvaccinated individuals raises a myriad of ethical, social and even legal questions. As part of the conditions, government has stipulated that businesses will face sanctions if they allow unvaccinated people into their premises. So in this video, I'll take a look at whether a venue can legally discriminate against unvaccinated people. Before we get into it though, please subscribe to the channel for more content like this and click the bell icon to stay across the latest videos from Kalkine Media. So we all know there are ethical concerns surrounding vaccine passports and the associated issues. But keep in mind, I'll be looking specifically at what the law states surrounding this issue. Let's start by taking a look at the Public Health Act 2010 for New South Wales. This is the act in which the public health orders relating to restriction of movement, gatherings and also the requirement for face masks have been derived from. The power to deal with health risk is contained in Section 7. This section makes clear that actions and orders can be made in order to reduce or remove any risk, prevent or conditionally permit access to areas or, and this is important, segregate or isolate inhabitants in order to deal with a public health risk and its possible consequences. At present, that would suggest that orders from the government themselves could indeed exclude members of society. Certain freedoms, based on their vaccination statuses, could also be stripped. As for businesses, well, it's somewhat unclear. In relation to the Public Health Act 2010, it's also worth mentioning that there are currently 4 separate legal challenges before the Supreme Court of New South Wales. One of the key positions of these challenges is the requirement of vaccines for certain workplaces. This is led by construction worker Almunir Kassam and also police officer Belinda Howcroft. These cases are set to be heard from September 30 and their outcome could have enormous ramifications for the Public Health Order Act 2010. If those challenges are successful, the requirement of mandatory vaccinations in certain circumstances, such as for employment as an officer or a construction worker, could be overturned, which could then have a ripple effect on the approach of government and the entrance into venues more broadly. Let's also take a look at the Anti-Discrimination Act of 1977. This is the main piece of legislation which prohibits discrimination in New South Wales. This act covers a large range of discrimination, from age, sexual preference, gender and vilification of HIV and AIDS positive individuals. The most pertinent part of this act though for the current situation is discrimination regarding a disability. The argument being that someone who is unable to be vaccinated due to medical reasons is a form of disability. Discriminating based on disability is strictly prohibited, and a disability resulting in a medical exemption could be based on a mental, physical, or even an emotional disability. However, Section 49 of the Act, titled Public Health, states that nothing in this part renders unlawful discrimination against a person on the grounds of disability if the disability is an infectious disease and the discrimination is reasonably necessary to protect public health. Once again though, this is extremely grey, given that those who have been double jabbed can still contract and spread the virus. Furthermore, if someone has not been double vaccinated, but undergoes testing and returns a negative result for COVID, or has developed natural immunity from the virus that would in fact pose no higher threat than that of a vaccinated person. In a hypothetical scenario, a person with natural immunity returning a negative COVID test realistically presents no infectious disease or public health threat to that specific business. And going by the letter of the law, that spells danger for businesses to deny such an individual. Finally, we also need to look at the Disability Discrimination Act of 1992, a federal piece of legislation. Whilst the Act more broadly suggests that you cannot discriminate against a disability, Section 48, titled Infectious Diseases, is the most relevant to the current situation, and it contains 2 key clauses. This part does not render it unlawful for a person to discriminate against another on the ground of the other person's disability if the person's disability is an infectious disease and the discrimination is reasonably necessary to protect public health. Now, according to Section 109 of the Constitution, Federal law, such as this 1992 Act, would override the 2010 Public Health Order, and that becomes relevant for the narrow language contained in the Disability Discrimination Act of 1992. The section states specifically, if the person's disability is indeed an infectious disease, they can be discriminated against. But because being unvaccinated doesn't automatically equate to being infectious with COVID, discrimination and refusal of entry on those grounds could very well be unlawful. If businesses are to employ this approach to unvaccinated customers looking to utilise their services, they could very well be sued, even without a medical exemption. And for those holding a medical exemption for not being vaccinated, the risk of a lawsuit to businesses is further amplified. If you enjoyed the information contained in this video, then please make sure to like, share, and of course, subscribe to the channel for more similar content. And please leave your comments on the video about what you think for this loaded issue. And of course, don't forget to press the bell icon to stay across the latest from Kalkine. For more information, just head across to the website, kalkinemedia.com. I'm James Preston, reporting for Kalkine.